All right, so today we're going to talk about the cases that you were assigned to read. I've got some other stuff for you. We may do a negligence exercise, and that'll be all for today. You will have a quiz Monday night based on your lecture outline, the cases that you've read, the McDonald's article, and anything that's said in lecture. Anybody have any questions on that? All right, y'all, everybody getting the hang of the rhythm of how we do it. Sounds good to me. So let's start with Dykstra versus Darling, which is the defamation case. Anybody ever heard of either of the parties in this case? Y'all are too young to know who Lenny Dykstra and Ron Darling are. I give you a pass, Miss Loretti, because they're not Italian. Right. Don't watch the sport. They're retired, like they're old guys like me now. So it's not that you should know who they are. So, who sued who in this case? Who sued who, Amber? That sounded accusatory. I didn't mean it that way. Tell us who sued who. Dykstra versus Darling. Yeah, that's right. Lenny and Ron. Who's the plaintiff? Anybody, who's the plaintiff? Lenny Dykstra was the plaintiff, and he sued, who's the defendant? Ron Darling. Good. What did Ron Darling do that made Lenny Dykstra want to sue him? Anybody? Defamation. Good. What was the defamation, Tim? The alleged defamation.
Publishing a book accusing Dykstra of yelling a racist remarks at an opposing player. And they were teammates back in the 80s.
All right, good. So Ron Darling wrote a book about his time in the game of baseball. He was teammates with Lenny Dykstra. He wrote some unflattering things about Dykstra, and Dykstra sued him for it, for defamation. Would this be libel or slander? Libel, right. Libel because it's written. Good. Very good. So is this a civil case or a criminal case? It's a civil case. This is a tort, so we know that's civil. And this is in the state court system in New York. So after, let's go through the passage of the book that Dykstra takes exception to. What are some of the bad things that Ron Darling wrote about Lenny Dykstra? I say bad things, not necessarily defamatory. We're going to go back through them and see if they're defamation. What are the bad things he said? Right, an all-time thug. What else? He said he gets away with murder. He was careful to say murder in the figurative term. What else is in there that if you were Lenny Dykstra, you would take exception to? Criminal in every sense. That's not very nice.
He treated people like shit, walked around like his shit didn't stink, and was generally a shitty human being.
Very good. I would not be happy if somebody said that about me. All right. Have you heard anything yet that you think would qualify as a statement of fact, a false statement of fact? Anybody? Not yet? What about thug? Say that a little louder, Levi. Maybe. What is a thug? Is that really bad? That's thug's close, maybe. What about generally a crappy person? It's an opinion, right? And we know that that's not defamatory. He wrote that Dykstra had faced some criminal charges and been sentenced to jail. Is anything about that defamatory? Not if it's true. Good. Love them all my lawyers in training here. Not if it's true. He went on to say that during the World Series that year that Dykstra yelled at the pitcher on the other team a bunch of insults, including foul, racist, hateful, hurtful stuff. Anything in there that might be defamatory?
Maybe the accusation itself, but he's not specific as to what he's saying.
Right.
That could be opinionated.
What did Dykstra take? What is Dykstra's case based on out of that paragraph? Yep, the racist part. That's the one he's picked out to say that was a false statement of fact. The judge in this case, when you read the opinion, says that one of the hardest things to do in defamation cases is to discern opinion from fact sometimes, right? Can we make the argument that racist? Can anybody make the argument that that is an opinion? It's what I think about somebody. Like I call them ugly or dumb or bad, cocky. I could say I'm just using it as an adjective. Can you make the argument that it's a statement of fact? I could do that. Racist means that you have prejudice against other races. Yeah. So if it's an adjective, it's more like an opinion. If it's a noun, it's more like a fact. That'd be the argument there. So based on that paragraph, Lenny Dykstra sued Ron Darling for defamation. His damages would include, would you say that they're mostly compensatory? That they're mostly general damages or special damages? Special damages being, remember, the ones we can calculate like we have a receipt. General damages being the ones that the jury just has to make up their own calculation.
They would be mostly general.
Mostly general. Read me some of them, Damien. What are some of his general damage claims?
Loss of opportunities, financial damages, emotional distress, and mental anguish.
All right. Emotional distress, mental anguish, shame, disgrace, ridicule, loss of standing, harm to reputation. The more special damages would be financial damages, loss of opportunities. Those would still be hard to prove. He'd still have to go in there and say, well, I was a spokesperson for Maybelline, and after this book, they fired me. So I could make some special damages out of that. But things like mental anguish and emotional distress and all that fall under the category of general damages. All right, so Dykstra filed the case, and before this case even went to trial, what did Darling do from a procedural standpoint? He moved to dismiss the case, right? You're allowed to do that. You're allowed to say, Judge, there is nothing to this case, and I'm asking you to dismiss it before we even go to trial. Judges will sometimes do that. Did the judge do that in this case? Did the judge grant that motion, Juliet? He actually did. Faith is nodding. He did grant that motion. But in granting that motion, he wrote out this opinion to tell us why he's granting the motion to dismiss. He gives us his rationale and a roadmap to his thinking of why Lenny Dykstra doesn't even get to have a trial in this case. All right, so you're at the bottom of page 2 there. Make sure you see that Easter egg there. This case is brought to you by a certain fast food restaurant. That one. I don't want to tip off my online people. They got to read the case just like y'all. So then the court gets into what the relevant law is. And you can see that the court gives you the definition under New York law of what defamation is. And then the court lays out for you at the top of page 3 what a plaintiff has to prove in order to make out a claim for defamation. A false statement of fact, published to a third party without privilege or authorization that causes harm. The same general elements that we looked at last week for torts. Interestingly enough, Darling's defense, the author's defense, is not that he didn't say something defamatory. His defense was what?
His character's so bad that he can't be defamed any further.
I can't make his reputation any worse than it already is, no matter what I say. That's not something we talked about last week in defamation. And that's something that is, as the court says, very rarely applied. It's hard to think of somebody whose reputation is so bad that we can't make it worse. But that was Darling's defense. Judge, you don't need to worry about whether or not it was defamation. You just need to know that it doesn't matter what I said about him. Even if it was, his reputation is so bad I can't hurt it worse. So then the judge goes on to apply the law as they laid it out to the facts of this case as they've already been laid out. In the judge's doing so, he talks about balancing different interests. What's Dykstra's interest in this case? Well, Darling's is going to be free speech, right? Yeah, the authors, we have an interest as society in protecting free speech. So that's one of the interests the court is balancing. What about for individuals like Dykstra? What's their interest? Yeah, we want to be able to, we do have an interest in individuals being able to protect their name. We do have an interest in not being lied about publicly. So the court is weighing those two things. What were as you read through the judge's application of the law to the facts, what were good facts for Darling? What were all the good facts for Darling? Looking at about the middle of page 3 on down.
Because Dykstra was a public figure, he had to put forth that it was published with actual malice. And I guess.
Okay, that's a good, I'm glad you brought up that point because I skipped that a minute ago. When the court was given the definition of defamation under New York law and was setting out all the things you'd have to prove, the court did tack on an extra element for public figures. I think we did talk about this last week, but anybody who's a public figure has to prove all those regular defamation elements. And then on top of that, they've got to prove actual malice, meaning the person did it knowing that it was false and in a mean way. It's a very basic way to say it. Damien.
So I see that it says knowing its falsity or with reckless disregard for the truth. I know what falsity means, but what does it mean to be reckless?
Reckless disregard for the truth would mean like you should know it's not true, or it would be really easy for you to figure out it's not true. You're not allowed just to have somebody, like if I told you that so-and-so, that a public figure was a child molester, and you don't get to just repeat it just because I told it to you. If it's something that you would know, if you could check and see if it was easily verifiable, reckless disregard for the truth would be pretty something that would have to be argued over. I mean, it's not a clear, bright line definition test. That makes sense. All right, so Dykstra had to prove all the regular elements of defamation plus actual malice. So on page 3, what are all the good facts then for Darling? What all supports his argument that Dykstra's reputation is too bad to be tarnished any further?
Here it says, based on the paper's surveillance motion, prior to the publication of the book, Dykstra was infamous for being, among other things, racist, misogynistic, and anti-gay, as well as a sexual predator, a drug abuser, a thief, and an embezzler.
All right, so he already had, that was a good fact for Darling. Dykstra was already well known to be a bad guy in a lot of different ways. Okay? Did y'all catch where a lot of this, the public knowledge about Dykstra's being a bad guy came from?
I think it was the 2009 GQ magazine article.
That? His autobiography. Dykstra wrote his own book saying all these bad things about himself. So the court is saying, not only are all these things well known, but they're well known because you put them out there and you confirmed them. So those were great facts for Ron Darling. Any good facts for Dykstra, in your opinion? You're Dykstra's lawyer. What are any good facts for you? What's the best argument that you could make for Lenny Dykstra if you're standing up in front of the judge?
They all know about the best, but one of them was that Dykstra alleges that Darling knew there was no video evidence to corroborate or disprove the story and conspired to defame Dykstra to sell books that they condemned against Dykstra for some previous dispute.
Okay, good. So he said one. I know I've just gotten so numb to this that I keep going without flinching. He said that, and that totally bested my train of thought. Start that again, Nick.
Basically said that no video evidence.
That's right. No video evidence. So he's saying, yeah, how convenient for Ron Darling to make this up when he knows there's no way to verify it or disprove it. He's just doing this to sell books and out of a personal beef with me. That doesn't give him the right to go around and trash talk me like this. If I'm Dykstra's lawyer, I would also say something along the lines of, so what, he's a bad guy. It still doesn't, we still have an interest in this country in not having people go around and being bad-mouthing us and making our reputation worse. All of this assumes that what Darling is saying is not true, right? Because truth would be a defense to defamation. So those are all good facts, mostly good facts for Ron Darling. What about the fact that, Prue, you brought this up. There were a bunch of other articles written by ESPN, GQ, and a bunch of other things. What had Dykstra never done to them? He never sued them, right? The judge said, if this is all so bad, why didn't you challenge when they said it? It really comes down to what's probably a pretty personal beef between these two guys, is what it sounds like to me. And I think the judge kind of scolded them in the end by saying our court has better things to do with our time and resources than referee whether or not you said something ugly 30 years ago, when there are people who are suffering today and who have really actually been harmed by stuff. And so the judge concludes that this is a case that didn't even need to go to trial. Any questions about Dykstra versus Darling?
What was the original topic of the book itself?
The topic of the book was just a memoir of Darling's time playing baseball.
So he wasn't even the center of the whole story of that book.
Dykstra was not the center of the book. Darling was telling a story about Game 3 of the World Series in 1986, when Dykstra allegedly shouted a bunch of awful stuff at the Red Sox pitcher. I think it's a personal beef between those guys. Is kind of what it sounds like. The judge didn't want to waste any more time. The judge already had to waste enough time just to get to this point and to sit down and write this opinion. Thoughts, comments, observations on Dykstra versus Darling? None?
What was the question?
Thoughts, comments, observations about this case? What comes to mind?
Just a waste of time.
A waste of time?
Dude's reputation was already bad enough. There was no reason to be on that side about somebody saying something about him he had already confirmed.
Well, let me ask you this. The court said that Dykstra was libel proof, basically, right? Can you think of something that Darling might have written that would have crossed the line into defamation and where the libel proof doctrine wouldn't apply? Is there something he could say that's so much worse than what's already known about him?
Probably accusing him of committing a crime against somebody.
Okay, a crime against somebody. He was already well known as somebody who did commit crimes. What kind of crime?
Maybe a crime that he hadn't been charged for.
A crime he hadn't been charged for. Like? Say that again? murder, child rapist, something, say really bad, like these other things aren't bad. I do think it's possible that Dykstra could still be defamed. It's just going to take something really, really special and really, really false in order to do that.
The fact that you can't think of anything is kind of crazy.
Yeah. I mean, the court gave a pretty long list of ways in which his reputation was bad. You know, bad sport, bad person, actually convicted criminal, racist or homophobic, all these other things that he had come out and said. All right. That is all for Dykstra versus Darling. I think I said this to you last week, but if you're ever interested and you just Google current events defamation cases, you will see so many of them brought up. It's a really popular tort right now to use. And you will know when you read it or you look at any cases or you hear about them in the future that if they involve public figures, that public figure is going to have to prove not just the regular tort, the regular elements of defamation, but also actual malice. Let's move to the Willingham versus Hudson case then. This is a somewhat local case. For those of you that aren't from this area, Mitchell County and Baker County, Georgia are south of here. In the southwest corner of the state, we could probably get to Camilla in an hour and 15 or 20 minutes or so. It's a rural part of our state. They do have a hospital down there in Camilla, but not a very big one. And in 2020, tornado came, or I'm sorry, not 2020, 2000. A tornado came through that area in the middle of the night and injured a bunch of people, which caused an influx of patients, an overflow basically, more than they could handle at the local hospital in Camilla. Who is Charlotte Willingham and who is Dr. Hudson? Who can tell me what's going on with them?
She's the plaintiff and the doctor.
All right, she's the plaintiff and the doctor is the defendant. What happened to Miss Willingham? She was injured in the tornado. What kind of, you don't have to be, I'm not expecting you to be doctors, but like basically what was injured?
She had a laceration on her thigh, I think.
Okay.
And like something on her ear, and then I think there was one other, but I don't know.
Pretty deep cut on her thigh.
The thigh was the biggest.
A foot injury. Yeah, and something on her ear. So we don't know exactly how the tornado did that, but she was cut up pretty bad. She ends up at the ER in Camilla. How did Dr. Hudson end up at the ER in Camilla? He got called in by who?
By the hospital, or wait, yeah, the hospital contacted him and requested his assistance, although he wasn't an on-call physician or ER backup physician on that date. He and other doctors arrived at the hospital and began treating him.
Good. So they're in the middle of the night. They got more people than they can handle. They have an emergency situation. They need all hands on deck. They just start calling anybody in the community they know that might could help. Get them to come on in and pitch in. So you already said, Damien, I think Dr. Hudson, was he on call that night? What kind of doctor was he? Family practice. Did he ever work in the ER?
At that point in time, he wasn't employed by the ER, but
I think it says somewhere he did do emergency on call sometimes. So the fact that he was going to the ER would not be something he'd never done before. It was part of his job. It's just that it wasn't part of his job to be there that night. Make sense? All right. He ends up going to the hospital to quote unquote volunteer, and he treats Charlotte Willingham. And then what happens to her? Yep, she got an infection, and then what happened? Yeah, they amputated her leg. She loses a leg as a result of all this, and she sues Dr. Hudson for negligence, right? Medical malpractice is a negligence tort. Talked all about this last week. The duty of care for a doctor would be what? Say again, Damien.
Would be higher than for an average person.
It would be higher than for an average person in his capacity as a physician. But generally, what standard do we hold doctors to when they're treating us? That they do it what, James? A high standard. But what do we expect out of them? That they'll treat us appropriately and properly. That they will use the correct medical methods. That if they are sewing us up, they'll do it correctly. Basically, that they will be careful in giving us care. So her suit alleges that Dr. Hudson breached that duty. In other words, you treated me, you have a duty of care, and you were not careful because I ended up with an infection that ended up requiring an amputation. All right, that would be the duty, the breach, the causation. Do we have proximate cause here? Is it foreseeable that if you don't treat an infection correctly, the person could lose their leg? Yeah, we've got that. Does she have some damages? Yeah, she does. She lost her leg. So she can make out a claim for negligence. That doesn't mean that Dr. Hudson is liable yet because he has a defense. What is his defense?
Good Samaritan law.
What does a Good Samaritan law do, Damien?
It protects any person, including a person's license to practice medicine and surgery. In good faith renders emergency care at the scene of an accident or emergency to the victim without making any charge should not be liable under the act.
You're good. No, that's the whole definition under the statute. That's an actual law passed by the Georgia legislature that gives immunity to people who render emergency care not for pay. In order for Dr. Hudson to use this defense successfully, he's got to prove all the elements in the defense that he rendered emergency care at the scene of an accident or emergency without making any charge. Those are the elements of his defense. Ms. Willingham takes exception to some of those elements, one of those being whether or not it was emergency care and whether or not it was at the scene of an emergency. What is her argument that he was not giving her emergency care? Anybody catch that?
Days later, the infection in her foot led to the infection.
Okay. Yeah. She said that when he treated her, I'm sorry. Ms. Willingham says she was not in critical condition at the time, and therefore it wasn't emergency care. Did the court buy that? No. The court did not buy that. The court said at the scene of being at a hospital doesn't automatically make it an emergency, but the fact that the ER was overflown and over capacity because of a tornado and a natural disaster, that did qualify as a scene of an emergency. And that even though she wasn't in critical condition, it was still emergency care. She's still in the ER. She still needed care immediately. It wasn't like she went in for some routine thing that could have been stopped and returned to later. She had to be treated right then. What about the issue of compensation for services? Did Dr. Hudson get paid for being there that night? He did not, Luis. That's right. What if he had gotten paid for being there that night? Could he still use the Good Samaritan defense? He couldn't. Right? So this only applies to people who are there giving emergency care at the scene of emergency without compensation. Dr. Hudson said throughout the discovery phase, when they're asking questions and gathering information, he said, I didn't bill her for this. He had the evidence to show that he did not get paid for it. Nor did he bill anybody else. Thank you, Julia. That's exactly where I was going. If he had billed everybody else but her, what would you argue that looks like? You just didn't bill her because you screwed up and you want to be able to use the Good Samaritan defense, right? You billed everybody else that night. Sketchy, as Tim says, that you didn't bill the only person you screwed up on, assuming he screwed up. What about the argument that, well, he is an employee of the hospital? Isn't that a good argument for her?
But it says that he was not required to report for duty.
He was not required. He was not on call that night. He was not. Does anybody have any pushback on that? I mean, basically, he's getting to say, I'm doing the job that I'm hired for and paid for there, but because I was there voluntarily that night, I should be able to be uncareful.
But he's.
I'm not responsible for what happened.
But he's not. It said earlier, unless I'm misunderstanding it, that he wasn't an on-call physician, nor was he.
Help me out. I thought that he
Because he's a local.
is a primary care, family care physician. But I think somewhere it says Dr. Hudson's employment agreement. So he had a contract. That'd have been something we would have wanted to get in discovery. Let me read your contract and see what if it covers this. He was required to work 40 to 50 hours per week based on the need for a full-time family practitioner and to work on call to back up ER physicians on a rotating schedule. So this was something that he did for pay from time to time. It wasn't like if I'm a eye doctor and they call me up in the middle of the night and we're like, hey, we need all the help we can get. Can you come up here and help? And all of a sudden I find myself in the ER cleaning out somebody's leg wound that I clearly don't have any experience or any knowledge about. Dr. Hudson knew how to do this. He was an ER physician. It's just that he wasn't supposed to be there that night and he was not paid for it. That's the difference in negligence or not in this case. Any thoughts, observations, comments on Willingham versus Hudson? Damien.
So I'm just curious, if she were to have named the hospital itself in the lawsuit, would things have looked a little differently, or would liability be shifted to the hospital?
So that's a good question.
They charged her medical bills and statements submitted by the hospital.
So could she have sued the hospital, and would the hospital be liable for negligence? So then the duty of the hospital would be what? To only employ doctors that are careful, or only allow people in the emergency room that know what they're doing, I'm thinking out loud.
Yeah.
If he had come upon her on the side of the road, there would be no way to bring the hospital into it. I think the hospital would have some insulation because it was still an emergency scene and not like their normal ER, a normal night at the ER. Employers are responsible for negligence committed by their employees. So,
but could it have been like one of those no fault situations?
Could have been. And in fact, I'd be very surprised if she hadn't sued Dr. Hudson and the hospital system. I mean, typically, if you're going to sue an employee for negligence, you're going to sue the employer too. They've got deeper pockets and insurance and things like that. Might as well go after as many people as you can. So I'd be surprised if they didn't do that. I don't know how it could be, Damien, that the reason that this case is just the doctor is that the hospital settled with her. And all that was left was the case between her and Dr. Hudson. That's my guess on that. But I'm glad you brought that up. I'd like to know the rest of the story, as they say. Good question. Any other thoughts, comments, observations? All right, let's do, while we're talking about negligence for a second, go into your content, and I posted some negligence scenarios. And I think it says for class discussion on 9:30, but we didn't get to it. So pull up. There's two of them. Pull up the paintball one. Hold on, I got to connect to the internet. Come on. Oh, I actually have this on my computer. I didn't even need to connect. We're doing paintball first. All right, everybody reading that paragraph while I've been fumbling around. Take a second and read that. All right, William opens and operates a warehouse with a paintball gun course. And there are several possible acts of negligence here. So we'll take them one at a time. William does supply everybody that participates with guns, the paintballs, and goggles. Lisa, on her way into the warehouse, trips on a broken step when entering the building. William keeps meaning to fix it, but he hadn't got around to it yet. She sues him for negligence. What's the duty of care that William has with respect to the premises? To maintain it in a safe way, specifically the stairs, to make sure they're not dangerous, that they work. What would be the breach here?
He knew about it because it says that he was meeting.
Yep. He knew his steps were broken and he didn't do anything about it. He's got a duty to keep them in good working order. He didn't. So we have duty and breach. Do we have proximate cause? Was his failure to fix it a foreseeable cause of her injury? Yeah. You don't keep the steps up, somebody can trip and fall and hurt themselves. Did she have damages? Assuming that, yes, she needed medical care or whatever for her leg. She's got a good negligence case. Any defenses for William that you can think of?
He would probably have a waiver. So, like, how would that affect it?
Good question, Jackson. He probably did make everybody sign a waiver.
But if you're entering the business, you haven't signed a waiver.
He might not have signed it yet. Although nowadays, they make you click on everything before you even get out of the car on those places. But good point. Most people have not signed the waiver until they get in the premises. Also, the waiver would probably cover what?
The paintball specifically.
Yeah, the paintball specific risks and things like that. I'm glad you asked that, Jackson, because when it comes to waivers, it's not, you can't waive liability for everything. You can't just say, no matter what happens to you, you agree not to sue me. You still have to be careful. You can waive liability for things that you specifically warn them about, that they know about, that are obvious, that they know what they're waiving. But you can't just say, if you come in here, you forfeit the right to sue me no matter what happens.
He may have a transfer of liability if he doesn't actually own the warehouse.
Mm-hmm.
It says he just operates the warehouse, so if there's a landlord involved, then the landlord has to approve of the repair.
That is a good point. So it might not be necessarily a defense to Lisa, but he might have somebody else he could bring in that ought to be responsible. Good point. All right. Who else got hurt? Matt's goggles have a missing strap that causes the goggles to fall, and as a result, Matt gets shot in the eye. Matt sues for negligence. What is William's duty with respect to the goggles? Yeah, that they work. Did he breach the duty? Should he have known that the strap was missing? Yeah, we would say that a reasonable person in his position, if his job is to supply safety goggles, would also include making sure that they're in working order. Was his failure to make sure the goggles were working the proximate cause of the injury? In other words, is it foreseeable that if the straps don't work, somebody could get hurt in the eye? Yeah, that's foreseeable. And assuming that Matt has damages, then he has a negligence case. What about Jackie? She got hit with a paintball while she was playing. She got paint on her. She sues William for negligence. Does he have a duty to keep her from getting hit with paintballs? No.
And that's a foreseeable risk on her part.
Yes. So even though William didn't have a duty to make sure she didn't get hit, even if he did, his defense is assumption of risk. That's an obvious, it is foreseeable that if you play paintball, you may get hit by paint. You may get paint on your clothing. Those things hurt like hell too if you get hit at close range on your skin. I don't know if any of y'all have ever done that. I don't even know if paintball's still a thing. It is.
There's a good place in the brain.
There's nothing here.
They make you sign waivers like crazy growing up.
They do. I'm sure they do. Any good business person is going to get as much waived as they can. All right, so Jamie's goggles break. William gives him another set. Instead of taking the new set, Jamie takes the broken set because he likes the way they look. He gets hit in the eye with a paintball when his broken goggles malfunction. What is William's duty with respect to the goggles again? Make sure they're safe, good working order. Did he breach that duty? He did or did? Well, he may have on the when depending on how they got broken or whatever. But then he gave him a working pair. All right, is that a breach of his duty? No, he's fulfilling his reasonable person care, the standard of reasonable care there. His defense would be what? Even if he did have a duty to do all that. What is the defense William has? So we call that what? Assumption of risk or misuse. Misuse is a little bit harder because goggles are meant to be used with paintball. But if you knowingly use something that's defective, then that, in other words, his defense is that's on you, Jamie. That's a legal term. It's on you. William put up a billboard with exciting pictures that are causing motorists to rubberneck and slow down, which is causing a traffic jam, which causes one motorist to be late for his appointment, which causes him to run a red light 2 miles past William's establishment and run into Kate, who is crossing the street. Kate sues William for negligence. Does William have a duty to advertise safely, I'll call it? Does William have a duty to keep stuff off of billboards that might cause accidents? Arguably, maybe. I mean,
But like, that's such a subjective thing. You can't foresee all that happening.
right. So the problem with Kate's claim then is that even if William had a duty to not post what he did, and even if he breached that duty, Kate's claim fails because, Levi, it is not proximate cause. Was it the actual cause? Yeah, it was the actual cause. I mean, if William hadn't put it on the billboard, people wouldn't have slowed down and looked. It wouldn't have caused a traffic jam. It wouldn't have made so-and-so late, so he wouldn't have had to run the red light and Kate wouldn't have got hit. So it's an actual cause, but in negligence, that's not enough. We got to have proximate cause. Yeah, that could also be superseding cause, which is that something else came in, another cause came in that was more responsible. That's another good defense. But proximate cause is right. It is not foreseeable that if you put pictures on a billboard, they're going to cause a public disturbance, that somebody's going to end up being late and they're going to run a red light and hit somebody 2 miles down the road. That's not foreseeable. So no liability for William with respect to Kate. Question?
So on the second one where Matt's goggles have a missing strap that caused him to fall and resulted in him getting shot in the eye. So my question is would it be a defense for him to say, maybe William wasn't the one who physically handed the goggles. He didn't bring them to him saying, hey, this is missing a strap, I need a new set. Could there be an assumption of risk defense?
Or like comparative negligence that it was,
Like you're telling me you didn't see that strap
yeah,
because everybody else has the strap.
you know better than to use goggles that don't have a strap on them.
Yeah.
I mean, so yeah, maybe some comparative negligence there. Maybe the goggles themselves were a defective product, and William could point to the manufacturer and say they make goggles that don't work. Matt doesn't care. Matt's saying, I got hurt and it was somebody else's fault. Now, y'all can point the fingers at each other and work it out between yourselves, but I'm getting paid. But that's a great point. Love the way y'all are thinking about this. All right, I want to tell you about a recent local case involving products liability, and this is, I'm going to read it to you. And this is not on your quiz. There is a law firm in town, or there's a lawyer in town named Jim Butler. Anybody ever heard of Jim Butler? I didn't name his firm because it's been named different things over the years, but he's one of the most famous plaintiffs lawyers in the country for suing companies for defective products. He made his biggest name suing, I can't remember what the automaker was, but it was many years ago, about the design of the vehicle where the gas tank was on the outside of the frame. I mean, not outside the vehicle, but the design of the car was such that the gas tank was in a vulnerable place and that they should have known that any collisions were going to result in an explosion. That happened. He sued whoever the automaker was. They won a huge verdict. And ever since then, and even before then, he's been a very prominent person to bring these suits. So in 2022, down in Decatur County, Georgia, which is south of here, it's almost into Florida. It's on the Florida line. And sort of down in the corner of Georgia, a couple, I want to get their names right. Well, I'm going to read it to you. Ford Motor Company owes more than $2.5 billion to the family of a couple killed in a 2022 rollover crash in the company's Super Duty trucks, a Georgia federal grand jury found, making the largest verdict in Georgia history. This was February of this year. The automaker now holds the dubious honor of having itself on the wrong end of two of the largest verdicts in Georgia history, both of which were awarded in recent years. A jury in Columbus, Georgia, found that Ford was mostly at fault for the deaths of two people after their truck rolled over in an accident. Herman Mills, 74, and Deborah Mills, 64, were driving in Decatur County August of 2022 in their 2015 Ford F-250 Super Duty truck. When it rolled over, the roof crushed down on them. Deborah Mills was driving the truck. Herman Mills was the passenger. When the truck struck a driveway drainage culvert, so it was off the road at that point, causing the vehicle to go airborne for about 81 feet before smashing into the ground and flipping over, according to the filings in the case. It was only a half roll, yet the roof catastrophically collapsed into the passenger compartment, Jim Butler said. Does anybody, just let me stop right here. Anybody have questions? What are your questions based on what you've heard? Anybody have questions about the wreck itself, Jackson? How fast were they going? What makes you want to ask that? They went 81 feet in the air, right? That's not normal. Even for somebody rolling, there must have been a pretty high speed. The drainage culvert wasn't on the road, right? So what's she doing driving off-road? How did she hit a drainage culvert? So we got some questions about that. Ford says that, this is predictable, while our sympathies go out to the family, the verdict is impermissibly extreme and not supported by the evidence. The company noted that juries in other cases found that the roofs of these trucks were not defective. So there have been other cases involving the exact same thing in other courts where Ford wasn't found liable. The motor company also argued that Deborah Mills suffered a cardiac attack. She had a heart attack as she was driving the vehicle that caused her to crash in the first place. She died on the scene. Took first responders 26 minutes to pry him out from under the collapsed roof. He died in a Florida hospital a little bit later. The jury in its verdict form did use comparative negligence and apportion the fault between Ford for the defective product and Miss Mills for her negligence in driving off-road. What's your guess on the proportion for each? Who wants to venture a guess? What percentage responsible for her, the
I
driver?
read it, so that's not.
You read it, so you can't say. What's your guess? What's your guess, Faith? How much would the jury say she was responsible? I know you don't know anything about it. This is a wild guess. 30%? Who thinks higher or lower? Who goes lower than 30%? Nobody? Who goes higher than 50%? Does anybody give her 0%? Nobody gives her 0. All right, so higher, 30 is sort of our floor, and most people think higher. The actual jury verdict was 15% her, 85% Ford. And again, we don't know what exactly the evidence was that the jury heard, but those are the basic facts. Butler said, and this is what you would have expected to hear during his closing argument, Ford has known for 26 years that people were getting killed and hurt by these weak roofs, and they have constantly refused to admit the danger or warn of the risk. The jury rendered the verdict in 2 phases, one for compensatory damages and then one for punitive damages. Anybody want to hazard a guess that hasn't read this on what the compensatory damages were? So I guess I should give you more insight on that. Compensatory, so the people who brought the suit would have been the children of the people who were deceased, because they can't sue, obviously, after they've died. So the lawsuit would have been for like wrongful death. In other words, we don't have the life of our parents anymore because of your negligence in the product's liability sense. The pain and suffering that Herman Mills had in the 26 minutes that it took them to get him out, and then whatever pain he suffered in going to the hospital and then dying later. Those would be sort of some of the things they would be asking for. Any guess on what the compensatory damages were? 100,000. 30 million. 30 million. 30 million. So you think that this, I'm guessing that Jim Butler and the plaintiffs did a really good job of making Ford look bad and of inflaming the jury's passion to get them all worked up about that. The punitive damages were $2.5 billion. So he must have really convinced the jury that Ford knew about this and didn't care. And they needed to be punished by that amount in order to not do it again and to send a message to other manufacturers that they better not do it either. I don't know. I guess this is such a new verdict, just February of this year. I'm sure Ford has appealed all this. I don't know, if the judge knocked down the 2.5 billion. I don't know the end of the story on this yet. It would be too soon for us to know. Any questions or comments or thoughts on that? None? Yes, sir?
I think it's worth noting, I know it said that they went airborne for 51 feet. It doesn't say 51 feet in, like, up, it's just 51 or 81 feet going out. But it was a half roll in which the roof catastrophically collapsed. I don't know if this is a result of that or if this is something that has been the case, but from my days in the dealership, one of the federal mandates that manufacturers have to follow is that vehicles have to be able to withstand 2.5 times its weight on the roof.
So my question, if I'm Ford, maybe I say there were safety regulations in place and we met them. Like the government has said they've got to be able to withstand this much weight, and we could. I don't know. I don't know where that went wrong. That maybe they were getting around it, or I don't know. But a half roll is, I'm not sure exactly what a half roll is. Does that mean you end upside down?
Like, you're like on your side. So like
Huh.
the pillars actually
Okay.
collapsed rather than the roof itself.
I see. Okay. All right. If y'all don't have any more questions, thoughts, comments, then that'll be all for today. I will see. Oh, hold on. I got to give y'all a color. What do y'all want the color to be this week? Green? Haven't we already had green? All right. The color of the week is green. See y'all next week.